Hello, 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 this is Eva the Elfpire, and today we're going to be going over a little bit of a cheeky situation. Not really cheeky, but I've seen a couple videos come out on this, and people don't seem to quite understand what happened here. So we're going over the state of Illinois Supreme Court and their overturning of the conviction of Jussie Smollett. For those who don't know, Jussie Smollett was the actor on Empire who basically staged a hate crime and then reported it to the police and made a big show of it. It was found out that that's what he had done, and he was required to, as part of a no prosequi agreement, he was supposed to pay $10,000 bond over to the city of Chicago for restitutions, and I think it was something stupid like 15 hours of community service. So not a lot of community service. Obviously people have a problem with it, but following that outcry, there was a re-indictment on him. He was prosecuted a second time. Now, some people might be wondering, well, what's going on here? What about double jeopardy? Well, that's more or less what the Supreme Court landed on, but we're going to go over it. We're not going to read through all 32 pages of this document because it's going to be citing probably a lot of case law, and it's probably going to be reiterating the arguments quite a few times. That's usually what happens in these kinds of documents. So we're going to be reading the background, and then we'll be reading the conclusion. That should be enough to get us an overview of what happened here. If you like this kind of content, please like, comment, subscribe, headbutt the notification bell as hard as you possibly can, and let's get into it. So this is in the Supreme Court of the State of Illinois, docket number 130431, the people of the State of Illinois, appealee versus Jussie Smollett, appellant. Opinion filed November 21st, 2024. So that means that this happened just a little bit ago, let me tell you what. Alright, so let's see here. Justin Rochford delivered the judgment of the court with opinion. Justices Novell, Overstreet, Holder, White, and O'Brien concurred in the judgment and opinion. Chief Justice Theus and Justice Cunningham took no part in the decision. So the opinion. The public justifiably expects the state above all others to keep its bond. Bowers versus State. Case law from 1986. Okay, so today we resolve a question about the state's responsibility to honor the agreements it makes with defendants. Specifically, we address whether dismissal of a case by no prosequi allows the state to bring a second prosecution when the dismissal was entered as part of an agreement with the defendant and the defendant has performed his part of the bargain. We hold that a second prosecution under these circumstances is a due process violation, and we therefore reverse defendant's conviction. Okay, so let's find out what happened. We should be able to find out what happened in the background. A complete statement of facts may be found in the appellate court's opinion. See 2023 Illinois, First Appellate Court, 220322. Okay, so we set forth here only those facts necessary for an understanding of the sole issue we decide. On March 8th, 2019, a grand jury returned a 16-count indictment charging defendant Jussie Smollett with felony disorderly conduct. See 526. Okay, so let's see here. These are probably statutes, laws that are being violated and such. The charges allege that defendant falsely reported to Chicago police officers that he had been the victim of a hate crime. 18 days later, on March 26, 2019, an assistant state attorney explained in open court before Judge Stephen Watkins that the state was moving to no pros the charges. The assistant state attorney explained the decision to the court as follows. So real quick, for those who do not know what a no prosequi means, and I might be pronouncing that wrong, I usually would pronounce that wrong. So that basically means choosing not to prosecute for whatever reason. A dismissal of the charges, so to speak. So let's see here. Judge, on today's date, the state does have a motion in this case. After reviewing the facts and circumstances of the case, including Mr. Smollett's volunteer service in the community and agreement to forfeit his bond to the city of Chicago, the state's motion in regards to the indictment is to no pros. We believe this outcome is a just disposition and appropriate resolution to this case. Okay. I do have an order directing the clerk of the circuit court to release bond number D1375606 payable to the city of Chicago to be sent directly to the city of Chicago Department of Law, and there's an address and the person there who takes care of that on behalf of the city. It is to note that the amount of the bond was $10,000. The trial court granted the state's motion to no pros and to release defendants' bond to the city of Chicago. Then on April 5th, 2019, a retired appellate court justice filed a pro se motion to appoint a special prosecutor in the matter of People of the State of Illinois versus Jussie Smollett. The motion raised questions about the resolution of the charges and the manner in which the Cook County State Attorney, Kim Foxx, had recused herself. After briefing and argument, Judge Michael Tuman entered an order granting the appointment of a special prosecutor. In the order, Judge Tuman reviewed the facts of the case and wrote that the disposition of the case by way of a no prosequi had shocked officialdom as well as the community. Judge Tuman noted both then Mayor Rahm Emanuel and then President Donald Trump had issued statements condemning the resolution of the case. Judge Tuman specifically found that negotiations on the disposition had dated back to February 26, 2019, when First Assistant State Attorney Joseph Maggots wrote that the Cook County State Attorney's Office, now referred to as the CCSAO, could offer diversion and restitution but would indict if something could not be worked out. On the February 28th of 2019, the chief of the criminal division told detectives that they could no longer investigate the crime and that she felt that the case would be settled with the defendant paying $10,000 in restitution and doing community service. Judge Tuman had addressed at length the circumstances surrounding Fox's recusal. Judge Tuman found that once Foxx recused herself, appointment of a special prosecutor was required. Instead, Foxx appointed her first assistant, Joseph Maggots, as the acting state attorney for this matter. Judge Tuman found that Foxx had appointed Maggots to an entity that did not exist because there is no legally cognizable office of acting state's attorney. Really? Okay. Judge Tuman noted that in People v. Ward 326 Illinois, Appellant 3rd Division, 897 in 2002, the court had held that if a case is not prosecuted by an attorney properly acting as an assistant state's attorney, the prosecution is void and the cause should be remanded for prosecution by a proper prosecutor. Judge Tuman also cited cases where proceedings had voided because of the prosecutions by unlicensed attorneys. Judge Tuman concluded that there was no duty elected state's attorney to Cook County when defendant was arrested, charged, indicted, or arraigned, and there was no state's attorney in the courtroom when the no prosequi was entered. Accordingly, Judge Tuman determined that appointment of a special prosecutor was mandated to conduct an independent investigation of the actions of any person or office involved in this case and to determine if reasonable grounds existed to further prosecute defendant. Let's call it a re-prosecution, not a further prosecution, because that's what it is and that's what they are trying to do. Judge Tuman later appointed Dan Webb as special prosecutor. Following the office of the special prosecutor, her to refer as the OSP investigation, a special grand jury indicted a defendant on 6 counts of felony disorderly conduct. See, and it looks like a bunch of statute and like law and code and stuff like that for law, probably specific to Illinois. Let's see here. In an information release, which is part of the record, the OSP explained that reasonable grounds existed to further prosecute defendant because he had planned and participated in a staged hate crime attack and thereafter made numerous false statements to Chicago police officers. In the information release, the OSP was also stated that it had determined that further prosecution of defendant was in the interest of justice for several reasons. First, the OSP relied on the extensive nature of the false police reports and the resources expended by the Chicago Police Department to investigate them. Second, the OSP contended that the CCSAO's disposition of the case was not similar to how it disposed of similar cases. The CCSAO had stated in a press release that the case was being resolved under the same criteria that would be available for any defendant with similar circumstances, and the OSP sought documentary evidence that would back up this claim, and that CCSAO was unable to provide it. Third, the OSP disagreed with how the CCSAO resolved the Smollett case, and the OSP stated that it had obtained evidence showing that the CCSAO believed that the case was strong at the time it obtained the 16-count indictment against defendant. However, just 3 weeks later, the CCSAO decided to resolve the charges under the following circumstances. 1. Complete dismissal of the 16-count felony indictment. 2. Only punishment for Mr. Smollett was to perform 15 hours of community service. 3. Requiring Mr. Smollett to forfeit his $10,000 bond as restitution to the city of Chicago, a figure amounting to less than 10% of the $130,106.15 in police overtime pay that city alleges it paid solely due to Mr. Smollett's false statements to police. Not requiring that Mr. Smollett admit any guilt of his wrongdoing. In fact, following the court proceedings on March 26, Mr. Smollett had publicly stated that he was completely innocent. And 5, not requiring that Smollett participate in a CCSAO deferred prosecution program. Branch 9, which he was eligible to participate in which would require a 1-year period of court oversight of Mr. Smollett. Fourth, is the CCSAO decision-makers had been unable to identify any new evidence they learned of between indictment and dismissal that changed their view of the strength of the case against defendant. Defendant moved to dismiss the new indictment on double jeopardy grounds. He also moved to dismiss on the basis that the appointment of the special prosecutor was invalid. The trial court denied both motions. Defendant lawyer later hired new counsel, who moved to dismiss the indictment on the basis of the agreement he had reached with the CCSAO. Defendant argued that he had entered into a non-prosecution agreement with the CCSAO and that the agreement was executed and enforced. He further argued that the OSP was bound by the agreement because the OSP and the CCSAO were both agents of the state. Defendant performed his part of the agreement when he forfeited his monetary bond and satisfied prosecutors as to his performance of community service, and the state performed its end of the agreement when it dismissed the case against him. Defendant cited People versus Starks. Let's see here, in Illinois 2nd District, 441, 1985, for the proposition that agreements between the prosecution and the defense will be enforced, and if the defendant performs his end of the bargain, then the state must fulfill its part. Defendant further contended that public policy supports enforcing agreements between the prosecution and the defense. Defendant asserted that he had been duped by the state because it re-indicted him after he had forfeited a substantial bond to the city of Chicago in exchange for getting the charges dismissed. The trial court heard oral argument on the motion. During oral argument, counsel for defendant argued that what happened here was more egregious than in other Illinois cases where the prosecution reneged on a deal. Here, the deal had already been enforced, and the OSP was attempting to resurrect something that had already been decided. The trial court denied the motion, and the court stated that Judge Tooman had found that there was no state attorney running the show at the time because of the confusion caused by the recusal announcement that was publicly made. Accordingly, the court stated that it was not going to challenge Judge Tooman's order or his reasoning that could not find a way to grant pretrial relief. Following a jury trial, defendant was convicted of 5 counts of felony disorderly conduct. The trial court sentenced him to 30 months probation, with the first 150 days to be served in the Cook County Jail. The court also ordered him to pay a $25,000 fine and a $120,106 in restitution to the city of Chicago. Defendant appealed, raising 13 issues. 13 issues, okay. The appellate court described his appeal as challenging virtually every aspect of the second prosecution that resulted in his convictions and sentence. Okay. The appellate court rejected all of his arguments and affirmed his convictions and sentence. Relevant to his argument that the second prosecution was barred because he had entered into a non-prosecution agreement with the CCSAO, the appellate court majority held that the second prosecution was not barred because the first case was disposed of with a null prosequi. The majority stated that well-established Illinois law provides that a null prosequi is not a final disposition and will not bar a second prosecution for the same offense. The majority acknowledged the dissent's argument that the state's right to re-indict after a null prosequi can be bargained away when making a bilateral agreement. However, the court stated that no Illinois court has ever applied principles of contract law in interpreting the scope of a null prosequi disposition in a criminal case. The majority considered several cases where agreements between defendants and prosecutors were enforced but determined that they were all distinguishable. The court concluded that here, the record was silent regarding any non-prosecution agreement between the CCSAO and Smollett, and that the only disposition requested by the CCSAO was a null prosequi, which does not impart finality. Now, here's a problem that I have with that statement, because it was stated in the prosecution's actual statement here. Let me see if I can come back up here. And here we go. Okay, Mr. Smollett's volunteer service in the community and agreement to forfeit his bond to the city of Chicago. The state's motion in regards to the indictment is to null pros. We believe this outcome is a just disposition and appropriate resolution to this case. What that means, like, unilaterally, is clearly the CCSAO believed that this was to mark finality. That's what they were betting on, and that's what they went ahead with. So, that being said, let's see here. Defendant raised 13 issues, and yeah, okay, so we're back down here. Justice Lowell dissented. Justice Lowell would have found the second prosecution barred by the agreement the defendant reached with prosecutors. Justice Lowell agreed with the majority that a second prosecution is not barred when the state enters a unilateral null. However, Justice Lowell cited State versus Kalberg, which is Connecticut in 2017, for the proposition that the state can bargain away the right when making a bilateral agreement with a defendant. Justice Lowell argued the report that the OSP filed with the trial court detailing the findings of its investigation showed that the CCSAO had entered into an agreement with defendant. The report also explained that the statement the assistant state's attorney read in court when charges were dismissed was drafted in conjunction with defendant's attorney. Justice Lowell also pointed out that the assistant state's attorney use of word disposition and resolution when entering the null showed that the CCSAO intended finality, which we just went back up real quick to check. That's exactly what I believe as well. So let's see here. Justice Lowell argued that the majority's contention that the null did not bar further prosecution was unsupported legally and factually. Justice Lowell cited Illinois case law establishing the contract principles apply in the pre-charging phase. Justice Lowell discussed Kalberg at length. She found persuasive the Connecticut Supreme Court's decision of null prosequi orders that are entered as a unilateral act by a prosecutor versus those that are entered as part of a bilateral agreement with a defendant. In the latter situation, re-prosecution is barred after a null if the defendant has performed his obligation under the agreement. Citing Kalberg. Justice Lowell would have applied these principles here. Because defendant gave up something of value in exchange for the resolution of the original case, he cannot be re-prosecuted. Justice Lowell then wrote, while that result may have appeared unjust to some, another trial court judge unrelated to the proceedings cannot unilaterally renege on the deal and grant the authority to a special prosecutor to violate a deal that bound the state. See State versus Platt, 1989, stating a deferred prosecution agreement may not, however, be rescinded simply because the state on reflection wishes it had not entered into an agreement at all. I would surmise that's probably what happened here because of the public outcry at how light the punishment was. That does not violate contract law, but would be manifestly unjust and would make every agreement the state enters into with a defendant tenuous, leaving defendants wondering whether public outcry would destroy the carefully crafted negotiation with the state. See People versus Starks. Public policy considers public policy considerations and reverence for our justice system. Disfavor reneging on such agreements and should never be outweighed by a cacophony of criticism as to the terms of the agreement. I completely agree. Like, while we may not agree with a court's decision, a court deciding to yield to public pressure instead of sticking to the law is entirely inappropriate, in my opinion. Let's see here. We allowed defendant's petition to leave to appeal. Okay, so now it's going to go into analysis, which I already said we're not going to go through. We got enough of the background. We're going to go ahead and scroll all the way down here to the conclusion. So let's get on down Chinatown. Get down to Chinatown. Now, I imagine the conclusion is probably only like the last 2 pages. So, yeah, here we are. Conclusion. We are aware that this case has generated significant public interest and that many people were dissatisfied with the resolution of the original case and believed it to be unjust. Nevertheless, what would be more unjust than the resolution of any one criminal case would be a holding from this court that the state was not bound to honor agreements upon which people have detrimentally relied. As the Supreme Court of Pennsylvania recently stated when enforcing a prosecutorial promise not to prosecute, it cannot be gainsaid that society holds a strong interest in the prosecution of crimes. It is also true that no such interest, however important, ever can eclipse society's interest in ensuring that the constitutional rights of the people are vindicated. Society's interest in prosecution does not displace the remedy due to constitutionally aggrieved persons. And this was in Cosby. Okay. That court further noted the consequences of failing to enforce prosecutorial promises when a defendant has relied on them to his detriment. A contrary result would be patently untenable. It would violate long-cherished principles of fundamental fairness. It would be antithetical to and corrosive of the integrity and functionality of the criminal justice system that we strive to maintain. We reverse the judgment of the appellate court, reverse the judgment of the circuit court, and remand the cause with directions for the circuit court to enter a judgment of dismissal. Judgments reversed, cause remanded with directions. Chief Justice Theus and Justice Cunningham took no part in the consideration of this decision or case. And there you have it. So a quick little summary. In these 2 arguments with the overturning of the conviction on the line, the prosecution, represented by the Office of the Special Prosecutor, argued that the second prosecution of Smollett was justified. They contended that a no prosequi dismissal of charges does not preclude a second prosecution. This is based on well-established Illinois law, which holds that such a dismissal is not a final resolution of a case and does not bar reprosecution. The prosecution emphasized that no non-prosecution agreement existed between Smollett and the CCSAO at the time of the dismissal. The OSP also pointed out that the original resolution of the case was unusual and lacked proper documentation supporting the fairness of the deal, thereby justifying a second prosecution. Smollett's defense, however, argued that the second prosecution violated his due process rights because he had entered into a non-prosecution agreement with the CCSAO, which was performed when he forfeited his bond and completed community service. Smollett contended that the agreement was binding, and by fulfilling his obligations, he had an expectation of finality regarding the dismissal of the charges. He further argued that the second prosecution violated contract principles as the state had already executed the agreement and could not renege on it. The defense maintained that such an action would undermine the reliability of agreements between defendants and the state and set a dangerous precedent in future cases. In summary, basically what happened here is the prosecution claimed the second prosecution was valid under Illinois law, and the defense argued it violated an agreement that had already been executed and should be honored under contract principles. The appellate courts and the circuit courts actually backed up the prosecution. However, it made it all the way up to the Supreme Court, who said, no, this is clearly double jeopardy. This is clearly a re-prosecution when a deal had already been reached, regardless of whether the public was angry at that deal or not. Does not necessarily mean that Jussie Smollett was innocent. He was guilty. He was not charged because he made a deal with the prosecution to $10,000 bond back to the city of Chicago, which, yeah, is woefully under what it costs the cops to actually investigate those false claims. But this is really now where you look at that prosecution office and you go, well, why were you so light on him? Why did you enter this? You can't just go back, especially a retired appellate judge. It's kind of wild that he decided to, like, stick his head in like that after the situation had already been resolved. That's gonna do it for this video. Again, this was just something that I saw. A lot of people were like, oh, he's cleared of all charges, he's innocent, he's getting out, and he is getting out. He is not clear. Well, he's cleared of all charges in the sense that charges are not being brought against him, but it's due to a non-prosecution agreement that the CCSAO actually announced publicly on television, which was a $10,000 bond and the community service. There you go. That's how the law ended up breaking down, and whether or not you believe Smollett deserved more, because I do believe that that was a woefully light punishment. However, it doesn't give the government the right to violate your rights. And you have a right not to be prosecuted more than once for the same crime, especially when it's already gone through the court process, however short that process might have ended up being. Alright, so that is this video. Everyone have a good day, and I will see you on the next one.